Number 56, Andino versus Mills. Counsel?
May it please the court, I'm Tim O'Shaughnessy from Transit. I'd like to reserve 2 minutes for rebuttal. When a police officer is healthy and retires, his or her pension begins the very next day. When the police officer is eligible for ADR benefits, the ADR benefits begin the very next day after the police officer retires, and they continue until the end of the police officer's life, seamlessly without a gap between the years in which the police officer would have been earning salary and the years when the police officer would have been earning her retirement benefits. When CPR 4545 was extended to public employees in 1984, the Assembly Committee report explicitly stated that it contemplated that ADR benefits would be a collateral source. Now, plaintiff raises 3 arguments in opposition. The first is that ADR benefits actually replace ordinary disability retirement benefits, or that ADR benefits were intended as a reward for being injured in an accident.
Can I ask
How does that, excuse me, how does that account to the fact that there's this view that the ADR benefits are intended as a show of gratitude? How does that account for whether or not that can be an offset category to category?
Well, Your Honor, frankly, we believe that it's not relevant. What happened in 1940 when the legislature first came up with ADR benefits is that it decided, for reasons that aren't really recorded, that when someone is injured by an accident in the line of duty, they'd get a 3/4 pension. Injured in the line of duty but not by an accident, or injured not in the line of duty, they'd get a 50% pension.
So what accounts for that?
But that isn't entirely accurate, is it? I mean, they get a 50% pension after 20 years, but if they work 37 and a half years, they get a higher pension, don't they?
Well, that's a service pension. That's if they're healthy.
That's an ordinary service pension.
Well, we have to be careful. We call
Okay,
that a service
go ahead.
pension, and then there's an ordinary disability pension,
Right.
an accident disability pension. So
But my point is if they work for their full life in the job, they get a 75% pension. And they also get it may not be 75, but it's around there, that number. And then if they're injured in the line of duty, they immediately get a 75% pension.
Well,
Am
actually,
I correct about that?
The service pension, I believe, is about 50% and comes after a minimum of 20 years. Ordinary
Well,
disability.
The service pension, I would disagree with you on it. It is 50% after 20 years. And then if you work, I say this as a son of a policeman, who worked 36 years and got something over 70% when he retired from the Buffalo Police Department.
That's correct, because it's
Right.
based on the final year's salary, and the salary continues to go up. So the fact of the matter is the difference between ADR and ODR is meaningless under the Oden and Bryant rule, because all you do is you look at the category of the jury's awards and the category of the award or of the collateral benefit.
Well,
In this
but
case,
what about, so and correct me if I have this wrong, but at 20 years, right, if the person had made 20 years, they could retire and continue to get, without any sort of discount on their pension, to earn outside income. I mean, you have all these police officers who go out and get second careers, whether as investigators for the Legal Aid Society or the DA's office, wherever they may go, they get second careers. How does that factor in here?
Well, the only way it factors in is that this shows you that the ADR covers both lost earnings and lost pension, because once the individual on ADR retirement passes that 20th year, they also, just like someone with a service pension, have no limit on the outside income they can.
So turning to our particular individual.
Yes.
She goes out, she's not quite at 20 years, right?
Right.
And should this, the way we look at this, transform at some point when she does hit 20 years? in terms of
Well,
how,
it doesn't.
how does that get calculated in?
It doesn't because of the terms of an ADR pension and the terms of ADR benefits. They start and they seamlessly go, they increase throughout the period the plaintiff would have been working and into the period to the end of the plaintiff's life, in the period where the plaintiff would have been retired.
Let
So
me
we-
try Judge
but-
Feynman's question a different way. As I understand it, you're saying that the ADR benefits, let's say after the 20th year, are compensating for two things, both the pension that's been lost and the earnings that the person could have been made while the person was working in some other employment like a private security guard.
Well, actually, up until the 20th year,
No, but I'm asking about after.
okay, if I.
Go ahead.
Your question was that two things happen afterwards, and my answer is, actually, they replace lost earnings before the 20th year. And they have a cap on outside earnings, and they have the requirement that the disabled officer must come in for a medical exam if requested. Then once you hit the 20th year, in which the theoretical police officer stops working, stops earning salary, and starts getting retirement benefits, a pension, then the accident disability benefits continue seamlessly, and that requirement about the pension and showing up for a medical exam is removed, because now we're in the years where the person would have been earning a pension and would not have had a limit
See,
on.
the fundamental, I think there's a fundamental disconnect. A pension is not a wage. A pension is an income that you receive based upon either your wage plus your years of service. That's how a pension is calculated. Each of the various forms that pensions take, here there are each of those four different types. Each of those various forms are all based on some combination of a formula based on what your wages were and what the time you had in. And then this benefit is given to you. But you're requiring us to say in your argument that pensions are equivalent to wages, and therefore you would get an offset in both categories. And I have a hard time to that for me to see that, because you can either have an offset, a full offset for pensions because they're equivalent and it's in line with our case law in Odin, or it's equivalent to a wage and you might be eligible for an offset there. But it can't be the same thing.
Well, Your Honor, I disagree that it can't be the same thing.
Okay.
It covers both time periods, and it treats the period where the police officer is earning a salary in one manner, and.
You understand what I'm saying, though, at least the nature of the argument.
I
A
do
pension is a
understand.
benefit that you're given as a result of the time you've put in. And the legislature can put any restrictions they want on it, which they've done with these various restrictions. It's not the same as a wage, which you get based on on hours that you work, and you're given compensation immediately for that.
But it has been, it's a very nice benefit, really, that these police officers
Yeah, but
realize
they're-
if
but-
once they're injured, of course. But what it does is
But
it
they
puts them
may
in.
earn it, but they don't necessarily get it, right? Because if they are found to be capable and fit to work.
That's right, it can be
It
taken
will be
away.
reduced by
can be
either the
taken
amount
away.
they make, or if they don't, what they could have made, correct?
That's correct. But the point is that it puts them in a position that they would
So
have
not,
been
let me just,
had they
just to follow
continued.
that up, so then it's not, in that sense, earned and can't be reduced or eliminated for a period of time. If they're found to be able to actually work, correct? That's the point of
That's
the
correct.
potential
That's
annual
correct.
medical exam?
That's correct, although then I guess they would go back to work, and they could still qualify for a pension, but I think that's the thing that happens very
Rarely.
rarely, yes.
I think so.
Thank you, counsel. Counsel?
May it please the court, my name is Brian Shute. I'm here for the plaintiff. The point I think Judge Fahey was making is one that this court made back in 1946, the Giannatato case that cited. That was the one where the part where I've talked about in our brief is that pensions are presumed to be, in the words of the court, full and adequate compensation was not received at the time of the rendition of such services. The legal presumption is that the pension is a payment for those services that were previously provided. In Gina Tettle, the facts were that
But what are we to make of the fact that indeed, if they're found able to be employed, that it can be reduced and in fact reduced to zero?
I think what it means is, amongst other things, that you certainly don't have, use the term a match. They are different. They're different in a material sense in two different ways, apart from all the technical differences. They're different in one sense, and that is that with the award, the tort award, should the plaintiff die next week, next year, those payments will continue towards the end of the term to her children. The award for ADR continues for life, however long or short that might be, meaning that if she dies before the end of the term, her children receive nothing. The other sense...
Isn't that a function of how you structured essentially the award? That is, as I understood the jury award, there were dollar amounts, nominal, today's dollars, nominal dollar amounts to be awarded right now, and that pursuant to some agreement, you decided they would be paid over a period of time.
No, not quite, Your Honor. The only part, the requirement that to be paid over a period of time is CPLR Article 50B.
Yeah.
The only agreement that was made was in each instance, the jury essentially rounded up the amount given by the
I
plaintiff's
thought you were
economist.
talking about the choice that a recipient makes on what benefit, what type of benefit they receive. So, the benefit can live on after you take a reduced amount, and that applies
yes,
to ADR.
yes.
That's what I thought you were talking about before that.
No, yeah, but you're right, of course, Your Honor, that under the ADR benefits, if the person wants a death benefit, they can essentially pay for it.
At a
by taking-
fundamental level, though, doesn't it seem like if the jury is awarding you lost pension benefits and you're getting a pension, something has to be offset there?
Well, I appreciate, but we have a statute that puts the burden on the party seeking the reduction.
But they were going to get something, now they're getting this award. It seems to me the rest is math. The rest is figuring based on the 75% or what the expectancy was, figuring out the value of what you were going to get versus the value of this award. That's just a calculation to me, but as a fundamental matter, I don't see how you can say an award for lost pension is an offset by pension benefits.
Two reasons, Your Honor. One is simply the statute. I don't mean the legislative history, I mean the statute. The statute, it's at page 33 of my brief if you don't have a copy handy. The statute provides that in order to find that any future cost or expense will with reasonable certainty be replaced or indemnified by the collateral source, the court must find that the plaintiff is legally entitled to the continued receipt of such collateral source pursuant to a contract or otherwise enforceable agreement. Here's the part. Subject only to the continued payment of a premium and such other financial obligations as may be required by such agreement. You've just heard. These payments are subject to a non-financial determinant, i.e. appearing under 13-254A of the Administrative Code for that examination. And yes, Judge Rivera, to my knowledge, it is rare that a person who's been deemed an M. Yes, to be honest, in this case, she's really disabled. I don't see that happening, but nonetheless.
But if she's gotten an award for lost earnings, and the reason why she's not getting this ADR benefit before her normal retirement eligibility is because she's unable to work, and in fact, she is able to work, and she goes out and she earns money, then why isn't that a double recovery?
Because the statute, I didn't write the statute. The statute says, and remember, it replaces a common law rule where there were no deductions. This is the line the legislature has drawn, not in the legal history, in the statute itself. Subject only to the continued payment of a premium and such other financial obligations as may be required by such agreement. Now, if the city, in its wisdom, decided it will not have any requirement, it will rewrite its requirements so as not to impose a non-financial obligation, that would be different. But there's the statute. That's what it says. If I may, in the short time.
In Odin, we made clear that you're right, this is in derogation of the common law. We've said we read it narrowly and strictly and so forth. But Odin made clear that the point is to avoid duplicative remedies, right? That's
point-
what you're trying to avoid. So aren't we back to, as Judge Garcia pointed out, she's getting money as a pension, and you've got something that seems very obvious on its face. It works as at least a pension. Maybe it doesn't work as lost earnings, but it works as a pension. So I'm having difficulty following your argument.
The legislature wanted to end double recoveries, but not at any cost. And it clearly drew the line, both in terms of the burden of proof that, and in terms of the statutory standard, that any gray area is not going to be deducted. And if it's very simply, if it's subject to a non-financial obligation, that the statute says there's no deduction. If the legislature could have drafted the statute differently and could have drawn that line differently, but it didn't.
I guess on the most basic level, looking at the cases, the statutory framework and the purpose of 4545, the point is she's going to get money upon immediate retirement. This category of retirees gets ADR benefits. It's making up for any earnings they would have had but for this injury that induces the disability that then makes them unable to work. If they're able to work, that amount of money is reduced, perhaps to zero. And once they hit a particular time frame, which would have been the point in time in service they could get a pension, they get this money. It's not reduced in any shape or form. It sounds very much like a pension then. And I'm having great difficulty getting past that
Your
to
Honor, may I
understand your
suggest-
argument.
In the short time I have here, you've had two polar positions presented in the briefs. I want to suggest, in the short time I have here, I'm not conceding anything. I'm suggesting a mid-ground if you should disagree with me.
Okay.
There is a middle ground here. My adversary said something just now that I found somewhat surprising, that was not relevant supposedly. Why the 75%, not 50%? Not relevant. I think it's very relevant. You've just had, of course, a 4-3, two spirited decisions on the intricacies of that added 25%. What does it represent? It certainly doesn't represent greater economic loss. The loss is the same, regardless of how the injury is sustained. It cannot represent the greater services that is expected from the 75% ADR officer as opposed to the 50%. The only explanation that anyone has ever suggested is the explanation that the city itself successfully urged in the Walsh case to this court. The rationale for accidental benefits as opposed to ordinary benefits is that the public owes a greater debt of gratitude to those public servants who suffer death with disabling injuries as a result of performing the duties.
Let's say we agree with you. It can still serve as a pension, so what do we make of it? Are you saying that you only deduct a certain percentage of the ADR as the offset?
What I'm saying
Where are you
is
going with the argument?
it's simply not what the statute intended, and wrong and unfair to take an amount that is given to you as a reward and
Well,
to
I
now
thought you were arguing that the
25%.
Yes, well, that's what I'm asking you.
Yes.
What do we make of the 25? Let's say we agree with you on that. Is your point then that 25% should not be counted in the offset?
Correct. And that the middle ground, then, Your Honor, is that the 50%, the 2/3 of the 75% is count. You can't
Because weren't we struggling in those other cases with the fact that you could have a police officer who is heroically, injured in a heroic way, saving someone, and it's a line of duty 50%, and an officer who steps in a pothole can get 75%.
Yes, but, Your Honor, but I wouldn't suggest that because there's one problem in the law to now magnify it. I can't understand the rationale of saying we are taking your reward and redistributing it to the person who injured you. That's what we're doing with that money.
But
If you
as I understand it,
understand-
you're trying to justify this 25% as some extra thing, when I think we were struggling originally to see the justification for giving an extra 25% to the person who steps in the pothole and not the person who runs into the burning building.
I'm not disagreeing with, I think both the majority and dissent said, with perhaps different degrees of enthusiasm, that this was a matter that the legislature should attend to. I'm not disagreeing. I'm saying that it's fundamentally wrong to simply take the reward from a person who's been injured for her service and now give it to the person who injured her.
So then, without doing any high-level math, please, how does that affect the calculation that was done here?
It's very simple. Their economist said that the total ADR benefits throughout the entire life were $2.554 million.
Okay.
The set-off, if that's the middle line you choose, would be they get a set-off of 2/3 of that, 50%, and that would be the total. You can't have more than that, I would suggest. 2/3 of the 2.54, which comes out to be approximately $1.7 million, Your Honor.
Thank you, counsel. What about this apportionment
I'm
argument?
forced to say there's absolutely no basis in the law for that. First of all, it would be unpreserved. In the this was not raised in the appellate division. In the Supreme Court, we had a collateral source hearing. We called an economist. He said, I calculate this to be the accident disability retirement benefits, and I say that they should be set off against the jury's awards in this manner. Plaintiff did not call an economist, so there's absolutely no contrary position in the record as to how the
That's getting into the weeds of what this particular record is and not really telling us what the general rule should be. It may be that they have a failure of proof when it goes back, if it goes back.
Well, no, I'm saying what you just heard is unpreserved. You won't find in this record anything about let's just knock a third off of the ADR finding.
Let me ask you about the appellate division's decision to, where it says the jury's award for future loss of pension benefits, however, should have been offset by the total amount that plaintiff was projected to receive under that disability pension, effectively reducing the category damages to 0. Can you just explain that calculation to me?
Well, that's because the appellate division rejected our argument that the ADR benefits should be applied to the future earnings as well. So that's why they limited it to that, to the future lost pension. And in fact, the ADR benefits are greater than the future lost pension. The ADR benefits, however, are less, much less, than the combination of the lost earnings and the lost pension. So if the court agrees with us that ADR benefits should be set off against both, we go back to the collateral source hearing. Our economist said, well, I'm just going to take, I've figured out actually for past and future, it's 2.8 million of ADR benefits. And since the lost earnings period comes first, I'm going to apply it to lost earnings. And there's a little bit left, so it wipes out lost earnings, and there's a little bit left to wipe out the award for pension. There are many other ways it might have been done. Different economists might have done it, but that's the only way it was done by an economist in this record, so that's the way it should stay.
That's the evidence you're presenting, that it should be first apply it to the future loss earnings. If there's anything left from the ADR, then you apply it to the pension.
Yes,
Am I
because
understanding correct?
because there are an offset against both.
Rather than aggregating the future loss earnings and the future loss benefits award and then just subtracting from that the total ADR? Does it
Well, I don't
matter?
think- Right. I think in another case, another economist might have done that, or there might have had an economist from the plaintiff and an economist from the defendant, and they might have slugged it out about the proper way to do it.
I guess
but
this is
that
what I'm
didn't
not
happen here.
understanding. Aren't we just coming up with a rule? You're saying this will vary from economist to economist that's in these collateral source hearings?
It may, but neither we nor the plaintiff challenged below the method of setting off the ADR benefits against the jury's awards. So the only questions before this court today are ADR benefits a collateral source to be set off against lost earnings? And are ADR benefits a collateral source to be set off against the lost service pension?
So we don't have to do any calculations? We don't have to send it back down to be recalculated? I thought you said that the
If-
AD didn't.
Well, if there's any recalculation necessary, it depends. If the court agrees with us.
Yes,
That they're both offset, then the work
Yes.
has already been done at the collateral source hearing, and there's nothing else to do. but-
as it stands. Because you
Right.
presented the evidence, and we
Right.
have the numbers.
Right, because our economist presented it on the basis that there's a set-off for both lost earnings and lost pension.
Thank you, counsel.
Thank you.
Ron, may I just give a record citation?
Yes,
1013.
thank you.